Welcome back to the channel for the video lecture series on company law. In today's lecture, I am going to cover the next portion of the first unit of our company law syllabus, which are corporate veil. And in the next lecture, I would cover the remaining portion of unit 1. So let's start with the lecture. Company enjoys a separate position from that of position of its owners. It is artificial but yet a person in eyes of law. Problems arise when this position of the company is misused. It is not incorrect to say that though the company is an unreal person, but still it cannot act on its own. There has to be some human agency involved so that company is able to perform its functions. When this human agency is working in the name of the company for achieving goals approved by law, the social order is not disturbed. But when this medium of operations begins to be tainted, conflicts arise. This authority rather becomes firing of bullets from someone else's gun. When directors or whosoever be in charge of the company start committing frauds or illegal activities or even activities outside purview of the objective or articles of the company, principle of lifting the corporate veil is initiated. It is disregarding the corporate personality of a company in order to look behind the scenes to determine who the real culprit of the committed offense is. Thus, whenever the personality of the company is employed for the purpose of committing illegality or for defrauding others, courts have authority to ignore the corporate character and look at the reality behind the corporate veil in order to ensure justice is served. This approach of judiciary is cracking open the corporate shell is somewhat cautious and circumspect. In the case of United States versus Milwaukee Refrigerator Transit Company, it was stated a corporation will be looked upon as a legal entity as a general rule and until sufficient reason to the contrary appears, but when the notion of legal entity is used to defeat public convenience, justify wrong, protect fraud, or defend crime, the law will regard the corporation as an association of persons. Supreme Court of India had adopted the similar thinking in the case of Tata Engineering Locomotive Company Limited versus State of Bihar and others, where the corporations petitioning had joined together and claimed protection under Article 286 of Constitution of India for non-imposition of tax on the sale or purchase of goods. The apex court held that if their contention is accepted, it would really mean that what the corporations or companies cannot achieve directly, they can achieve indirectly by relying upon the doctrine of lifting the veil. So let's now talk about when can the veil be lifted. The doctrine, though one of the most used doctrines by courts, is still, however, not running upon a hard and fast rule. The basis for invoking such operations does not follow a laid down policy. However, over the period of time, courts and legislatures throughout the globe have attempted to narrow down scope and applicability of the doctrine under following two heads. First one, statutory provisions. The Companies Act 2013 has been integrated with various provisions which tend to point out the person who is liable for any such improper or illegal activity. These persons are more often referred as officer who is in default under Section 2 Clause 60 of the Act, which includes people such as directors or key managerial positions. Few instances of such frameworks are: first one, misstatement in prospectus. Under Section 26 Clause 9, Section 34 and Section 35 of the Act, it is made punishable to furnish untrue or false statements in prospectus of the company. Through issuing prospectus, companies offer securities for sale. Prospectus issued under Section 26 contains keynotes of the company such as details of shares and debentures, names of directors, main objects, and present business of the company. If any person attempts to furnish false or untrue statements in prospectus, he is subject to penalty or punishment or both prescribed under the aforesaid sections, depending upon the case. Each of these sections create a distinct aspect that which type of incorrect information furnishing would make such person liable for what amount or serving term. Next up is failure to return application money. Under Section 39 Clause 3 of the Act, against allotment of securities, if the stated minimum amount has not been subscribed and the sum payable on application is not received within a period of 30 days from the date of issue of the prospectus, then such officers in default are to be fined with an amount of 1000 rupees for each day during which such default continues, or 1 lakh rupees, whichever is less. Next up is misdescription of company's name. The name of the company is most important. Usage of approved name entitles the company to enter into contracts and make them legally binding. The name should be priorly approved under Section 4 and printed under Section 12 of the Act. Thus, if any representative of the company collects bills or sign on behalf of the company and enter in incorrect particulars of the company, then such persons are to be held personally liable. Similar things happened in the case Hendon vs. Edelman, where signatory directors were held personally liable for stating company's name on a signed check as LR Agencies Limited, while the original name was L&R Agencies Limited. Next up, for investigation of ownership of company. Under Section 216 of the Act, the central government is authorized to appoint inspectors to investigate and report on matters relating to the company and its membership for the purpose of determining the true persons who are financially interested in the success or failure of the company, or who are unable to control or to materially influence the policies of the company. Next point, fraudulent conduct. Under Section 339 of the Act, wherever in case of winding up of the company, it is found that company's name was being used for carrying out a fraudulent activity, the court is empowered to hold any such person be liable for such unlawful activities, be it director, manager, or any other officer of the company. In the case of Delhi Development Authority versus Skipper Construction Company Private, it was stated that therefore the corporate character is employed for the purpose of committing illegality or defrauding others, the court would ignore the corporate character and will look at the reality behind the corporate wheel so as to enable it to pass appropriate orders to do justice between the parties concerned. Next point, inducing persons to invest money in company. Under Section 36 of the Act, any person who makes false, deceptive, misleading, or untrue statements or promises to any other person or conceals relevant data from other person with a view to induce him to enter into either of the following. First point, an agreement of acquiring, disposing, subscribing, or underwriting securities. Second, an agreement to secure profits to any of the parties from the yield of securities or by reference to fluctuations in the value of securities. Third, an agreement to obtain credit facilities from any bank or financial institution. In such circumstances, the corporate personality can be ignored with a view to identify the real culprit and make him personally liable under Section 447 of the Act accordingly. Next point, furnishing false statements. Under Section 448 of the Act, if in any return, report, certificate, financial statement, prospectus, statement, or other document required, any person makes false or untrue statements or conceals any relevant or material fact, then he is liable under Section 447 of the Act. If any document is sent from company to any place else, content of the documents are sent on the letterhead of the company. Now when this letter is received by any other person, he is supposed to be under assumption that he has received the letter from the company. This any other person here is persons appointed under the Act, such as Registrar of Companies. If he is furnished any false or untrue statement, that is also an offense. Thus, in order to determine the real guilty person who allowed such documents being released in the name of the company is to be found by way of lifting the corporate veil. Next point is repeated defaults. Under Section 449 of the Act, if a company or an officer of a company commits an offence punishable either with fine or with imprisonment, and this offence is being committed again within period of 3 years, such company and officer are to pay twice the penalty of that offence in addition to any imprisonment provided for that offence. Now let's talk about judicial pronouncements. Though the legislature has attempted to insert numerous provisions in the Act to make sure guilty person is pointed out as veil is pierced, there are instances where judiciary has played its part better and kept a check that no guilty person, due to a mere technicality, walks free. Under this, the first point is tax evasion. It's duty of every earning person to pay respective taxes. Company is no different than a person in eyes of law. If anyone attempts to unlawfully avoid this duty, he or she is said to be committing an offense. When strict rules are laid down for human being, why leave company? One clear illustration was Dinshaw Manakji Patent, where the founding person of four new private companies, Sir Dinshaw, was enjoying huge dividend and interest income, and in order to evade his tax, he thus found four sham companies. His income was credited in the accounts of these companies, and these amounts were repaid to Sir Dinshaw, but in form of a pretended loan. These loans entitled him to have certain tax benefits. It was rather held that purpose of founding these new companies was simple as means of avoiding super tax. Next point is prevention of fraud or improper conduct. It is obvious that no company can commit fraud on its own. There has to be a human agency involved to commit such acts. Thus, one may make efforts to prevent upcoming frauds. Similar thing was observed in the case of Guilford Motor Company Limited versus Horney, where Horney was appointed as managing director of the company provided he accepts the condition that he will not attempt to entice or solicit customers of the company while he is holding the post or even afterwards. However, shortly thereafter he opened a company in his wife's name which carried out a competing business to that of the first company, with himself being in management. When the matter was brought into the court, it was held that the newfound company was mere cloak or sham for purpose of enabling Sir Dinshaw to commit breach of his covenant against solicitation. Next point is determination of enemy character. The purpose behind formation of company is self-profit. A company will not attempt to do good towards society consciously. However, it may opt to cause damage instead. Similar things were observed in the case Daimler Company Limited versus Continental Tires and Rubber Company Limited. The facts were such that a Germany-based company was incorporated in England to sell tires in Germany. The Germany company had, however, held the bulk of shares in this English company. As World War I broke out, the English company commenced an action to recover trade debt. The question was brought before the House of Lords, which decided the case against the claimant, stating that company is not a real person but a legal entity. It cannot be a friend or an enemy. However, it may assume an enemy character when persons in de facto control of its affairs are residents of the enemy territory. Thus, the claim was dismissed. It was rather held in the case Schiff Frachet versus Van Udens Shipyard that if in such scenarios where a company is suspected to be of enemy character or is proved to be of enemy character, then such granted monetary funds would be used as machinery to destroy the concerned state itself. That would be monstrous and against public policy of that concerned state. Now let's talk about next point, liability for ultra vires acts. Every company is bound to perform in compliance of its memorandum of association, articles of association and the Companies Act. Any action done outside purview of either is said to be ultra vires or improper or beyond the legitimate scope. Such operations of the company can be subjected to penalty. The doctrine of ultra vires acts against companies was evolved in the case of Ashbury Railway Carriage and Iron Company Limited versus Hector Ridge, where a company entered into a contract for financing construction of railway lines, and this operation was not mentioned in the memorandum. The House of Lords held this action as ultra vires and contract null and void. Next point is public interest or public policy. Where the conduct of the company is in conflict with public interest or public policies, courts are empowered to lift the veil and personally hold such persons liable who are guilty of the act. To protect public policy is a just ground for lifting the corporate personality. One such scenario was in the case Jyoti Limited versus Kamaljeet Kaur Bhasin and another, where it was held that corporate veil may be ignored if representatives of the company commit contempt of the court, so punishment can be inflicted upon. Next point, agency companies, where it is expedient to identify the principal and agent concerning in an improper action performed by the agent, the corporate veil may be neglected, such as in the case of Bharat Steel Tubes Limited versus IFCI, where it was held that it doesn't matter and it isn't necessary that government should be holding more than 51% of the paid up capital to be the principal. In fact, in the case New Tirupur Area Development Corporation Limited versus State of Tamil Nadu, where government was holding mere 17.4% of the investment funds, it was found that Area Development Corporation was actually a public authority through the government. It was created under a public private partnership to build, operate, and transfer water supply and sewage treatment systems. Next point, negligent activities. Every company law distinguishes between holding and subsidiary companies. Holding companies under Indian company law are the companies which have right in composition of board of directors or which have more than 50% of the total share capital of the subsidiary company. For example, Tata Sons is a holding company while Tata Motors, TCS, Tata Steel are its subsidiary companies. In cases where subsidiary companies have been found with tainted operations, courts have power to make holding companies liable for actions of their subsidiary companies as well for breach of duty or negligence on their part, such as in the case of Chandler versus Cape plc, where an employee brought an action against holding company Cape plc for not taking proper health and safety measures, even though employee was employed in its subsidiary company. Employee was appointed in the year 1959 in the subsidiary company while he had discovered the fact that he is suffering from asbestosis in year 2007. When he was aware of this condition, it was that the subsidiary company was no longer in existence. Thus, he brought action against the holding company which was still in existence. This matter was held to be maintainable. Rather, holding company was held guilty and made liable as it owed duty of care towards employees. It was for the first time where a holding company, despite the fact that it's a legal entity separate from that of its subsidiary, is however liable for actions of its subsidiary. Next point, sham companies. The courts are also empowered to lift the corporate veil if they are of the opinion that such companies are sham or hoax. Such companies are mere cloaks and their personalities can be ignored in order to identify the real culprit. This principle can be seen in the prior discussed case of Guilford Motor Company Limited versus Horney, where it was held that the newfound company was mere cloak or sham for purpose of enabling the owner to breach his commitment towards covenant against solicitation. Last point, companies intentionally avoiding legal obligations. Wherever it is found that an incorporated company is deliberately trying to avoid legal obligations, or wherever it is found that this incorporation of a company is being used to avoid force of law, the courts have authority to disregard this legal personality of the company and proceed as if no company existed. The liabilities can be straightaway imposed on persons concerned. So, that was all about today's lecture, where I tried to explain the lifting of corporate veil theory. I hope the viewers understood the topic well, and to understand more such topics under company law, do come back for the upcoming lectures. And for that, do not forget to subscribe to the channel and turn on the notifications so that you don't miss any of the lectures. Thank you.